Imagine spending years on death row for a crime you didn't commit. Imagine knowing you're innocent while everyone tells you you're guilty. Imagine having an execution date, knowing you're going to die for something you didn't do, and being powerless to stop it. This isn't a hypothetical. It's happened over 200 times in the United States since 1973. Over 200 innocent people have been sentenced to death and later exonerated. That's over 200 people who came within days, sometimes hours, of being executed by the state for crimes they didn't commit. And those are only the ones we know about. How many innocent people have already been executed? We'll never know for certain. But experts estimate that at least 4% of people sentenced to death are actually innocent. That means 1 in every 25 people on death row right now may be innocent. This is the story of wrongful conviction, of justice gone horribly wrong, and of innocent people who survived America's death row. Glynn Simmons holds a record nobody wants. He spent more time wrongfully imprisoned than any other person in American history. 48 years. Nearly half a century. In 1974, Simmons was 22 years old when he was arrested and charged with murdering Carolyn Sue Rogers during a robbery at an Edmond, Oklahoma liquor store. Simmons maintained his innocence from day one. He had an alibi. He was in Louisiana at the time of the murder. The alibi didn't matter. He was convicted anyway. The conviction was based primarily on eyewitness testimony. Several witnesses identified Simmons as one of the perpetrators. Eyewitness testimony is compelling in court. Juries believe people who say, "I saw him, I'm certain." But eyewitness testimony is also unreliable. Study after study has shown that human memory is fallible, that stress affects recall, that cross-racial identification is particularly prone to error. Yet we still base death sentences on it. Simmons was sentenced to death in 1975. He spent years on Oklahoma's death row, waiting to die for a crime he didn't commit. His death sentence was eventually commuted to life without parole, but that offered little comfort. Life in prison for something you didn't do is still a nightmare. For decades, Simmons fought his conviction. He filed appeal after appeal. He maintained his innocence to anyone who would listen. Most people didn't believe him. He was just another convicted killer claiming innocence. But Simmons's legal team never gave up. They discovered evidence that prosecutors had withheld crucial information at trial. Key witness testimony became questionable. The case began to unravel. In 2023, nearly 50 years after his conviction, Glynn Simmons was finally exonerated. A judge ruled that he should not have been convicted. All charges were dismissed. Simmons walked out of prison at 70 years old. He had entered as a young man of 22. He had missed his entire adult life. No family, no career, no freedom. 48 years stolen by a justice system that got it wrong. When asked how he felt, Simmons said he had no anger but wanted accountability. He wanted the system that destroyed his life to acknowledge its failure. How much is 48 years of freedom worth? How do you compensate someone for half a century of wrongful imprisonment? You can't put a price on lost decades. No amount of money returns a stolen life. Simmons's case raises a terrifying question. How many innocent people have we already executed? People without legal resources, without dedicated attorneys, without evidence sophisticated enough to prove their innocence? How many Glynn Simmons died on death row while still claiming innocence? We'll never know. Kirk Bloodsworth became the first person in American history to be exonerated from death row through DNA evidence. His story changed the death penalty debate forever. In 1984, a 9-year-old girl named Dawn Hamilton was found dead in a wooded area in Maryland. She had been sexually assaulted, strangled, and beaten with a rock. The community was horrified. Police were under immense pressure to find the killer. Kirk Bloodsworth, 23 years old and a former Marine, lived in the area. An anonymous caller told police that Bloodsworth matched a police sketch of a man seen with a young girl that day. That was enough. Police brought Bloodsworth in for questioning. He had an alibi, but it didn't matter. 5 eyewitnesses came forward claiming they had seen Bloodsworth with the victim on the day of the murder. During his testimony, Bloodsworth made a statement that prosecutors would use against him. He had done something terrible that day that would affect his relationship with his wife. He was talking about a marital argument. Prosecutors implied he was talking about murder. No physical evidence connected Bloodsworth to the crime. No DNA. No fingerprints. No forensic link whatsoever. But eyewitness testimony is powerful in court. 5 people said they saw him. The jury believed them. Bloodsworth was convicted of rape and murder. He was sentenced to death. On death row, Bloodsworth refused to give up. He studied law books in his cell. He wrote letters to anyone who might help. He maintained his innocence even when his own family struggled to believe him. Then, in 1993, DNA testing technology advanced enough to test evidence from the crime scene. Bloodsworth pushed for testing. Prosecutors initially resisted. Why test evidence when we already have a conviction? But eventually, the testing proceeded. The DNA results came back. They proved conclusively that Kirk Bloodsworth had not committed the rape and murder. He was innocent. Bloodsworth was released after spending 9 years in prison, 2 of them on death row. 9 years of his life stolen. 9 years sitting in a cell, watching his execution date approach, knowing he was innocent and being powerless to prove it. The DNA that exonerated Bloodsworth later identified the real killer, a man who had been serving time for a different crime. The actual murderer had been free to harm others while an innocent man sat on death row. After his release, Bloodsworth became a prominent advocate for reforming the death penalty. He testified before Congress. He shared his story publicly. He said, "If you're going to have a death penalty, you better make sure you're getting the right person, because you can't take it back." Bloodsworth's case exposed a terrifying reality. The justice system gets it wrong. Eyewitnesses make mistakes. Juries convict the wrong people. Innocent individuals end up on death row. Since Bloodsworth's exoneration, DNA evidence has freed more than 20 people from death row. But DNA evidence only exists in a small fraction of cases. Most crimes don't leave biological evidence that can be tested. That means there are likely many more innocent people on death row who will never be able to prove it with DNA. Anthony Ray Hinton spent 30 years on Alabama's death row for murders he didn't commit. His case reveals how poverty, racism, and incompetent defense attorneys create wrongful convictions. In 1985, 2 restaurant managers were killed during robberies in Birmingham, Alabama. Police suspected the murders were connected. They arrested Anthony Ray Hinton, a 29-year-old black man who worked in a warehouse. The evidence against Hinton was circumstantial at best. Prosecutors claimed that bullets from the crime scenes matched a gun found at Hinton's house. That was essentially the entire case. No witnesses placed Hinton at the scene. No fingerprints. No confessions. Just ballistics evidence claiming that bullets matched a gun. Hinton had an alibi. He was at work, locked in a warehouse at the time of the murders. His supervisor confirmed this, but the alibi was dismissed. Here's where the story becomes infuriating. Hinton's defense was catastrophically inadequate. Alabama law required him to be represented by a court-appointed attorney because he couldn't afford a lawyer. The attorney was paid a maximum of $1,000 for the entire case. Think about that. $1,000 to defend someone facing the death penalty. The attorney hired a ballistics expert for $500 because that's all he could afford. The expert was not qualified. He had one eye and couldn't properly use a microscope. On the witness stand, he appeared confused and incompetent. The jury didn't believe him. Hinton was convicted and sentenced to death, largely because his defense was so inadequate that the jury assumed he must be guilty. For 30 years, Hinton sat in a 5x7 cell on Alabama's death row. He watched 54 men walk past his cell to the execution chamber. He heard them die. He lived with the constant knowledge that one day, it would be his turn. But Hinton never stopped fighting. Bryan Stevenson, a renowned civil rights attorney and founder of the Equal Justice Initiative, took on Hinton's case. Stevenson and his team hired qualified ballistics experts who tested the gun allegedly used in the murders. The results were definitive. The bullets from the crime scenes did not match Hinton's gun. The original ballistics evidence was wrong. The entire case was based on faulty forensic analysis. In 2015, the U.S. Supreme Court ruled that Hinton's defense had been inadequate. Alabama would have to give him a new trial. Prosecutors reviewed the evidence and realized they had no case without the ballistics evidence. All charges were dismissed. Anthony Ray Hinton walked out of prison at age 58. He had entered as a 29-year-old. 3 decades of his life gone. 30 years in a 5x7 cell, 23 hours a day, for crimes he didn't commit. When reporters asked Hinton if he was angry, he said something remarkable. "The state of Alabama took 30 years of my life. If I focused on anger and bitterness, they'd take the rest of my life too. I choose joy instead." Hinton became a powerful advocate for criminal justice reform. He wrote a book called The Sun Does Shine about his experience. He speaks publicly about the death penalty, about wrongful convictions, about the racism embedded in America's justice system. His case exposes several critical failures. Inadequate defense counsel leads to wrongful convictions. Faulty forensic science can destroy innocent lives. Racial bias affects who gets arrested, convicted, and sentenced to death. People can spend decades on death row. While innocent Hinton's story had a somewhat happy ending, he was freed. But think about all the others who aren't. The people without brilliant attorneys like Brian Stevenson fighting for them. The people whose cases don't get national attention. The people who die in prison still claiming innocence. Convictions 26. All 33. Oh, why do wrongful convictions happen? What causes the justice system to get it so catastrophically wrong? Research by the Death Penalty Information Center reveals disturbing patterns. When examining the over 200 death row exonerations since 1973, several factors appear repeatedly. The single most common factor in wrongful death penalty convictions is official misconduct by police, prosecutors, or other government officials. This includes coercing witnesses to give false testimony, concealing exculpatory evidence that would help the defendant, falsifying reports, or manipulating evidence, allowing or encouraging perjury, pressuring defendants to falsely confess. These aren't mere accidents. They're intentional acts by the very people supposed to ensure justice. And misconduct appears in 3/4 of cases involving Black defendants. False testimony and perjury. 67% of cases. 2/3 of death row exonerations involved false accusations or perjured testimony. Witnesses lied. Sometimes they were coerced by police. Sometimes they were offered deals in exchange for testimony. Sometimes they simply made mistakes. But their false testimony sent innocent people to death row. Unreliable forensic evidence. 33% of cases. 1 in 3 exonerations involves discredited forensic techniques. Bite mark analysis, hair comparison analysis, ballistics matching, and other methods once considered scientifically reliable have been thoroughly debunked. Yet these techniques continue to be used in court. Juries believe them because they sound scientific. Defendants are convicted based on pseudoscience. Mistaken eyewitness identification. Eyewitnesses are notoriously unreliable, especially in cross-racial identification. Studies show that witnesses often confidently identify the wrong person. Stress, lighting, distance, and the passage of time all affect memory. Yet eyewitness testimony remains one of the most powerful forms of evidence in court. Juries believe people who say, "I'm certain it was him." Inadequate defense counsel. Many wrongfully convicted defendants had incompetent, underfunded, or overwhelmed defense attorneys. Some lawyers literally slept through parts of trials. Some were disbarred shortly after. Some spent almost no time preparing a defense. When your life is on the line, the quality of your attorney shouldn't depend on your income. But it does. Racial bias. The data is stark. People of color are disproportionately represented among death row exonerees. Over 63% of wrongful death penalty convictions involve people of color, and 53.5% involve Black defendants specifically. Racial bias affects every stage of a capital case. Who gets arrested, who gets charged with capital murder versus a lesser offense, who receives a death sentence versus life in prison, and who gets executed versus having their sentence commuted. A 2014 study estimated that at least 4% of death sentences involve innocent people. That's a conservative estimate. The real number could be higher. For every 8.2 people executed in the United States, 1 person on death row has been exonerated. Think about that ratio. For every 8 executions, we discover that 1 person was innocent. How many innocent people have we already executed? Not everyone is exonerated in time. Some innocent people are executed before their innocence can be proven. Carlos de Luna was executed in Texas on December 7, 1989 for the murder of Wanda Lopez, a convenience store clerk who was stabbed to death in 1983. De Luna maintained his innocence. He said the real killer was Carlos Hernandez, a man who looked similar and had a history of violent crime. Nobody investigated Hernandez. De Luna was convicted primarily on eyewitness testimony. 6 years after De Luna's execution, a law professor conducted an exhaustive investigation. His findings were damning. The crime scene was covered in blood. De Luna's clothes had not a single drop. His shoes didn't match the bloody footprints at the scene. No physical evidence connected him to the murder. Carlos Hernandez, the man De Luna claimed was the real killer, had bragged to multiple people about committing the murder. He matched the description better than De Luna. He had a history of nearly identical crimes. The prosecution hid evidence from the defense. Witnesses were pressured. The investigation was sloppy at best, corrupt at worst. Many experts now believe Texas executed an innocent man. But De Luna is dead. There are no appeals for the executed. No justice. No compensation. Just death. Cameron Todd Willingham was executed in Texas on February 17, 2004 for allegedly setting a fire that killed his 3 young daughters in 1991. Willingham was convicted based on arson investigation techniques that have since been completely discredited. Multiple fire experts have reviewed the evidence and concluded the fire was likely accidental, not arson. The Texas Forensic Science Commission investigated the case after Willingham's execution and found that the original arson determination was based on junk science. The commission concluded that the evidence did not support an arson finding. In his final statement, Willingham maintained his innocence. "I am an innocent man convicted of a crime I did not commit. I have been persecuted for 12 years for something I did not do." Was he telling the truth? The scientific evidence suggests he was. Texas may have executed an innocent father who lost his 3 daughters in a tragic accident and was then killed by the state for it. Joe Arity was executed in Colorado in 1939 for the rape and murder of a 15-year-old girl. Arity had an IQ estimated between 46 and 63, making him severely intellectually disabled. He was coerced into confessing to a crime he almost certainly didn't commit. He couldn't understand the charges against him. On death row, he played with a toy train and seemed unaware he was going to be executed. In 2011, Colorado Governor Bill Ritter posthumously pardoned Arity, stating he was innocent. But the pardon came 72 years too late. Arity was already dead. These are just a few examples. There are likely many more innocent people who were executed before their innocence could be proven. Once someone is dead, there's little incentive to continue investigating. The case is closed. Justice, such as it was, has been served. Except justice wasn't served. Murder was committed. State-sanctioned murder of an innocent person. Since 1973, over 200 people have been exonerated from death row. That is over 200 innocent people who came within days or hours of being executed for crimes they didn't commit. Glynn Simmons lost 48 years. Kirk Bloodsworth lost 9 years. Anthony Ray Hinton lost 30 years. And Carlos De Luna, Cameron Todd Willingham, Joe Arity, and others lost their lives. The death penalty is irreversible. When we execute someone, there are no do-overs, no new trials, no exonerations, just death. The American criminal justice system is flawed. Police misconduct happens. Prosecutors hide evidence. Witnesses lie. Forensic science fails. Defense attorneys are inadequate. Juries make mistakes. In any other context, a 4% error rate would be considered catastrophic. Imagine if 4% of surgeries killed the wrong patient, or 4% of convictions in traffic courts sentenced innocent people to prison. We would demand immediate reform. But with the death penalty, we accept this error rate. We acknowledge that innocent people will be convicted and some will be executed, and we do it anyway. 27 states still permit the death penalty, though many haven't carried out an execution in years. The debate continues. Is it justice? Is it effective deterrence? Is it applied fairly? But beyond policy debates is this reality. Innocent people are on death row right now. Some will be exonerated. Others will die still claiming innocence. The question each of us must answer is, how many innocent deaths are acceptable? Is 1 too many? Is 10? Is 100? Because that's the trade-off. If we have the death penalty, We will inevitably execute innocent people. That's not a hypothetical. It's already happened. It will happen again. What's your answer?